Hey ladies and gentlemen, Mr. C here yet again, and we are here today to talk about our 7th Amendment. Now, the 7th Amendment is a very, very straightforward amendment, and it doesn't really require a whole lot of thought behind it. Well, if you know law and law terminology. Now, so I'm just going to jump right in. It's really not going to take us a long time, and this is probably one of the very few videos I actually stay well under. So, getting in. What does the 7th Amendment protect? The 7th Amendment protects two specific things. First, your right to a jury in like civil cases or cases that have to do with like money. And second, your right to basically not have the facts against you retried. Now I know what you're thinking. Isn't both those things already covered in the 5th Amendment under, juries and that one thing, double jeopardy? You're right, but that more or less has to do with criminal cases, not civil cases, and I'll get into that. Now, while the reexamination clause, which is basically the facts retried, you can't have facts retried, that has to do with both civil and criminal. But for the sake of the 7th Amendment, we're going to stick to civil. It covers criminal cases too, but we're kind of just going to lump that in with the 7th, and yeah, moving on. So, we're going to start off. What the 7th Amendment covers is, like I said, your right to have a trial by jury for civil cases and no re-examination of the facts. Let's jump in. So the Supreme Court has ruled out a few things. First off, just to get this out of the way, the Supreme Court has ruled what is a sufficient jury. Okay? A sufficient jury in two different court cases. One court case said that a sufficient jury under the 7th Amendment is at least 6 people. You cannot have 5. That was the other court case. The other Supreme Court case said that 5 people on a jury wasn't enough. And then a second court case, or technically the first court case, said 6. So there are two separate court cases. One said you need a minimum of 6. One said you can't have 5. Which you would think common sense they would be put together. But they were two separate court cases. Now that we have that out of the way, let's jump in. First off, I have to break apart what is a civil and criminal court case. So, there's two major types of court cases in the United States, or really in the world. Criminal and civil. Criminal is basically the state or the government is suing, or not suing, but bringing charges against someone as like you broke a law or something like that. That's criminal. A civil case is when you as a private individual are bringing someone else to court. Whether that be another person, whether that be the government or someone, where you as a private individual are bringing someone to court. Now, 99% of the time, don't quote me on that number, it's about monetary, it's for monetary reasons. Whether they owe you money, damage, property damage, things like that. There is a few other times you can bring, but most of the time it's for civil cases or for some type of monetary value. And it doesn't just mean physical like cash. It can mean property damage, tax, or not tax, like rental agreements, things like that. Now, getting it, what does it protect? So the 7th Amendment says under common law, and I'm going to get into common law in a second, your right to a trial by jury over $20 is safe. $20. Now, the thing is, that $20 limit is what many people, and I'm quoting Harvard Law School people, which is, Harvard Law, kind of a big deal, says that the $20 clause in the 7th Amendment is a mystery, is one of those great historical law mysteries. We don't know why our founding fathers put $20. We kind of feel that they put it in there so inflation, which basically means like, as time goes on, the value of the dollar drops. So $20 in 1791, when the 7th Amendment was first came into being, is about $2,000 plus dollars today. $20 back then is a lot more money than $20 today. $20 today will get you, 2 pizzas or 4 pizzas from Little Caesars. $20 back then would buy you a house, almost. Okay, it's a little exaggeration. So they were kind of, or the founding fathers, we feel, were just hoping that the $20 clause would just, with inflation and history, would just be pushed off to the side and wouldn't matter anymore. So it's really a mystery. You can even look those facts up yourself. So the $20 pushed out. What now today? What rights do you have today when it comes to trying someone or a trial by jury for monetary gain? The federal government said if you want to try someone in a federal court for monetary reasons, like you think someone owes you money, the minimum amount has to be $75,000 for a federal court case. And that's only if the person you're suing is from a different state as you. That also means country. Okay, so you could sue someone in a different state or in a different country. but the minimum value has to be $75,000. If you want to sue someone for $74,999.99 or less, then you have to sue them in your state court. And each state is different based on, like, you know, size of jury, who does the proceedings. Like, they vary greatly from state to state. Some states have, you know, you go to your state court. Some say you stay at your county court. It all depends. It varies state by state. So that's pretty much that for the $20 clause. We have much higher limits that protect your right to trial by jury when it comes to civil cases and things like that. Now, getting into what common law is before I go into the reexamination of the facts. Common law, we as the United States are one of only 4 major countries, and yeah, 4 major countries that follow common law. Us, Australia, Great Britain, and Canada are the only 4 major countries that follow common law. There's a few others that I looked over, but they're not major. Okay, what common law is basically, common law is a type of legal system where you don't have to have a physical law in place for it to be considered like part of the legal system. And let me explain that. So, like, let's say you have a court case. Okay, you bring something to the Supreme Court, and the Supreme Court rules something. That becomes what is known as a precedent. A precedent can be used in law as law. So that means is, if you're in other countries where they don't have common law, for you to use something in court, their government or whoever makes their laws has to sign something into law. It has to be an official law in the law books. In a country like ours where there's common law, it doesn't have to be officially signed into law. A judge could rule it or something like that. A good example is the Lemon Test. We talked about it in the First Amendment. There is no congressional law or state law that says the Lemon Test is a legal test you have to use. The Supreme Court put it up there and set a precedent to make you use it. So now we legally have to use it. Another case is the Miranda rights. Miranda rights weren't actually put into legal law. Congress didn't pass a legal law saying it. I think eventually they did, but when it first came into use, the Supreme Court set a precedent. And under common law, precedent becomes law. You don't have to actually sign it into place. Okay? We're one of only 4 countries that have major countries who have that. Now, getting into it. There's 2 things that I want to get to about common law. The 7th Amendment protects trial under common law for 2 circumstances. The first thing is there's a court case called U.S. v. Watson in 1812. And that set up the historical test. The historical test basically just says it's a test to determine common law. Again, another precedent under common law. What the historical test said was, when the 7th Amendment says common law, your rights are protected under common law, it means common law of 1791. Okay? And this is going to make a little more sense as I get into the reexamination of the facts. So, common law under the 7th Amendment means common law at the time of 1791. Now, the Supreme Court and Congress has ruled that things like copyright infringement and things like that also fall into common law. Common law protects those as well. Now, moving on. The other part of the 7th Amendment has to do with reexamination of the facts. What that means is, anytime a jury deems some type of fact in a court case, when you bring up facts and the jury decides on it, those facts cannot be re-examined. So, like, if a DNA test comes back or a testimony from witness comes back and the jury determines that, you know, it can be used or can't be used or something like that, the jury approves of those facts, you cannot re-examine them. You can't bring them back in for re-examination. You know, the defense or the prosecution can't reopen them. You can't do that. Only under certain circumstances you can. Okay? Normally you can't. There are certain circumstances where you can re-examine them under common law, and that's where the historical test comes into place. Some of the biggest examples are the entire trial is scrapped and thrown away and they do a retrial. In that situation, under common law says you can retry the facts now. And another thing is, if you appeal the courts under certain common law circumstances will allow you to retry the facts. Otherwise, once a jury says something on any type of facts, it's done. You cannot relook at them. And that's what the 7th Amendment protects. So, that's all I got time for, ladies and gentlemen, and really that's all there is for the 7th Amendment. Stay tuned for the 8th Amendment coming next. That is no excess fines and bail and no cruel and unusual punishment. Yes, we are going to talk about the death penalty. So, I'm going to stay under my time. Stay beautiful. Mr. T signing out. Oh, I didn't hit the button.